Hello and welcome to Questions for Judges, a production of ABOTA, Fort Lauderdale. My name is Jeff Adelman, and what we're trying to do here is bring different judges on the air, ask them about what works in the courtroom, things that they like, things they don't like, and a little bit about the judges as well. And today, for our first episode, I'm thrilled to have Judge Alan Forst from the 4th District Court of Appeals. Thank you so much for entertaining us today, Judge Forst. I appreciate that.
Well, I was just walking down the hall and some guy says, "Chocolate in here."
Well, you know, we do whatever we can to entice the judges on this show. Well, you have a very interesting background, and I think that it would be helpful for our members to know just a little bit about you before you actually got on the bench in 2013.
Okay. The abbreviated version, since the full version would take all 15 minutes. I was graduated Georgetown a long time ago, and I came out and got involved in a political campaign, and which is really when I determined which party I felt comfortable with at the time, and I ended up my candidate won, ended up getting appointed to a few positions, and ended up at the Department of Justice, and they said, you know, you really should go to law school, particularly if you want to stay at the Department of Justice. So I went to school at United Catholic University, and went to a few different agencies while I was there, and came out, went to a think tank for about a year, and ended up a couple of years out of law school as special assistant to Clarence Thomas. And he was a fantastic mentor, a great boss, and it turned out, you know, in time, a good person to have worked for.
Absolutely.
And after he became a judge, I ended up going and becoming involved with the Bush administration, the George H.W. Bush administration, at the Department of Labor. After that ended, I segged into the Clinton administration at an agency called the Merit Systems Protection Board. Worked, and then it's like, well, it's time to learn how to be a litigator. So became a litigator for the Census Department, and which has been in the news lately. And
yeah.
And then it's like, it's time to come to Florida. My parents live in Florida. My brother lives in Florida. So in the late 90s, I came down to a little place that I had never heard of, Stuart, Florida, and fell in love, and worked at a law firm for a while, and then I got the itch to go back in the public service, and was able to get appointed by Governor Bush to be the chairman of at the time, the Unemployment Appeals Commission, now the Reemployment Assistance Appeals Commission. Did that, and my best friend, Stephanie Ray, who's on the First DCA, but when she got on, she said, "This is great," and I said, "Would I like it?" She said, "You'd love it," and I said, "Could I handle it?" She thought about that for a while, and then decided that I'd be okay at it, at least. And I applied, and everybody that's watching this, I assume, is familiar with the process. And I felt sort of like the outsider. My career pretty much had just been in Martin, and mostly in Tallahassee, in Florida, and Washington, of course. But it all worked out, for me at least, and I was appointed by Governor Scott in March 2013 and started the next month.
Wow, so your experience goes far beyond just being a lawyer. You've been involved in lots of different aspects of lawmaking and litigation, and really you've run the gamut.
My federal positions were we're the counsel to the quasi the chair of this, the chair of that, the director of this. So there was some policy involved, and there was a lot of decision making. So it was good practice. It was all appellate. So it was a good preparation for my present job.
Well, let me ask you this. You came up to me at the officer dinner in January, and you said, "Jeff, whatever I can do to help the members of ABOTA, just ask." So again, I really appreciate you being generous with your time. But why is it that you feel so strongly to give back to ABOTA and other legal organizations?
It's twofold. One is I'm still feel like I'm acquainting myself with the community from which the Forst DCA is involved, which certainly includes Broward and Palm Beach and the 19th Circuit, which is where I was more familiar. The other part is I've always been involved with bar activities as a way. I think it's a great networking. It's a great public service activity. I was the president of the Martin County Bar about 5 years after I moved here, and then I was chair of the Labor and Employment Law section, and been involved with and continue to be involved. It's just a great way to meet people, and I used to feel like with labor and employment law there would be some just really great attorneys, and I felt, if you get to know them, then you're in a litigation, they're less likely to do everything, pull out all the dirty swords, and vice versa. And it's a good I think it's and that's ABOTA right there. It's all about professionalism and people breaking bread from both sides of the aisle, and as well, I guess all three sides, including the judges. Right. So I feel it's very important.
Yeah, professionalism and relationships. I remember at that dinner, John Richards was being honored. I had just litigated a case against him, but we're both ABOTA members, and it was really an honor to see him get Trial Lawyer of the Year at that dinner. So again, it really is important. Well, what kind of advice would you give someone who's obviously handing an appeal, they're writing a brief that you're going to be reading? What type of things could you tell them would be helpful to you who's reading that brief?
We recently had a request to enlarge the brief. The brief is the max is 50 pages, and there was a request to make it 80 pages. And the easy thing would have been said, sure, but no, there's a reason it's 50 pages, because if you have ad infinitum, there'll be ad infinitum issues, and you're going to not be focusing on the real issues that you feel that the trial court got wrong, or that you want to bring to the attention of the appellate court. So you need to focus on the handful of the real contentious issues that you feel need appellate review, and give the best argument. Keep it on argument. Don't no ad hominem attacks that judges frown on that. And again, very very focused on the pertinent issues, and assume that we're reading every word, because we are, of the briefs.
So not expanding it to 80 pages, I mean, brevity is what you're looking for. Let's get to the point.
Well, 80 pages could end up in 15 issues, and there can't be, well, yes, some things there are, but there's 15 issues. A lot of them are going to be very tangential, and it can be done very, very well in 50 pages. The best appellate attorneys in the country manage to stay within 50 pages.
Now, most of the time when somebody's doing an appeal, they're not going to get oral arguments. How do you decide whether or not to grant oral arguments?
Well, the first disqualifier is you have to ask for it. 99% of the cases that we hear oral argument are requested. In fact, I could think of only one case in 6 years where we requested oral argument that they had not requested. Mm-hmm. The second, in terms of requesting it, just saying I want oral argument because I feel it would help, a sentence like that, that's not the best way to ask for it. Why is oral argument requested? What's special? What's so special about this case? If it's just purely on the facts, and that's something that should be able to be brought forward in the brief. But if there's an issue that seemingly is of great public interest, that's something that we'll look at. If there's some conflicting opinions from either our court or from the other courts, that's something we'll look at. Or if it's just an issue that's still being sorted out, but flesh it out a little bit. in the request for oral argument to help us to determine it, because if we can't, well, we and also the other thing is it a case that seems like a lot of money has been spent, and this would not necessarily be a good expenditure of the client's money, although that's really a call for the attorney and the client to make.
Well, once oral argument is granted, what type of advice would you give to anybody who's presenting to the panel?
Listen, well, these are kind of obvious things.
Yeah.
Listen closely to the questions. Be prepared to respond, to know your record very well. We've gone for the record to some extent, but there's maybe some things that are not clear from the record. So be prepared to discuss the record. Know the various case law, particularly if there's conflicting case law. Know the cases that you cite. If you're going to cite a case, know them. If the other something that always amazes me is when the initial brief says we're relying on Jones versus Smith, and 5 different cites to it, and then the answer brief doesn't even address that. It's the first thing I'll look for in the answer brief. Well, what do they say about Jones v. Smith? And if it's not in there, that's the first thing I'll be asking in oral argument to the appellee.
Sure.
And I just did moot courts here at the Florida Bar, and the thing that we tell the kids that are arguing is, if you're the appellee, we should be seeing you furiously scribbling during the appellant's oral argument, so you're responding to them, and in rebuttal, don't make a closing argument. That's wrong court. You should be also furiously scribbling and rebutting. That's what rebuttal is called.
Exactly. Well, it's interesting. You mentioned that you worked with Clarence Thomas, who is famous for not asking questions on the bench, and he picks his moments. How do you determine whether or not you ask questions from the bench?
I'll go over the night before. Well, I'll meet with my clerks the day before oral argument, or sometimes a couple days before, and we'll discuss the cases that are assigned to me, that I'm the lead judge on, because that's the case that they've been immersed in, and then either the morning of or the night before, I'll sit down and go through. I write notes on everything. I go every case, and I'll go through my notes, and as I'm reading the case, I'll be like, what do they mean by this, or how are they saying that this case is inapplicable? And then I'll actually type my questions that I'm interested in hearing answered, and then sometimes as the case is going along, I'll try to pick up on something. And then sometimes it's seems like, okay, case seems to make sense, so let's see what they have to say and take it from there. And so sometimes it's, as they say, a hot bench. The three of us are just asking all kinds of questions, and sometimes I guess the attorneys need to read the bench, and sometimes it's like, okay, I see I have 14 minutes left, but I will sit down.
Some of the best arguments I've ever made are when I keep my mouth shut. If things are going the way I want, just keep it shut. So
it's possible to grab victory from the jaws of defeat, and it's also possible to grasp defeat from the jaws of victory.
Absolutely. And you mentioned that you have clerks, and you have 2 clerks.
I actually have 3.
3 clerks. And they're all attorneys, correct?
Yep.
Okay, so it's good to have kind of a sounding board back away from the bench and everything else, just to kind of run the different ideas by 3 other legal minds.
Right. So even for cases that we're just conferencing on without an oral argument, my clerks and I do essentially an oral argument where I'm asking them questions on the bench memo that they've done, and I'm hoping that the other clerks have read the bench memo. In fact, I'm getting new clerks in the next month, and I'll say you're going to be reading everybody's bench memos so that we could all discuss it. It's good preparation.
Absolutely. Well, again, I can't thank you enough for your time. I guess before we conclude, Judge Forst, do you have any advice for any young law students out there, young attorneys, about moving forward that are interested in getting involved in appellate law?
Well, I guess the best way is the best way is to do moot court and law review in law school, and get involved with various fraternal or organizations in law school. Try and get an internship during your law school years with appellate court, and then apply for a clerkship with an appellate court, particularly if that's what you're interested in. Although I guess federal trial courts do a lot of similar work to appellate court, and actually I have 2 law clerks that are leaving me. One just left and one's about to leave. One's going across the street to a federal magistrate, and the other ended up going to Kansas to work for a federal trial judge. So
Florida to Kansas.
Yeah, never been. So they certainly love the clerking aspect, and the one that left a year ago, he's clerking in Miami. So,
Any advice to anybody who is seeking to be a clerk for a judge?
Get your applications in early. Make sure you're well credentialed. It's very competitive, and become prepared for the interview. I'm always astounded. I think judges are very unimpressed when it seems like, oh, you're just one of 15 people that they're interviewing with, and they really haven't done any individual prep. They're just there to talk about themselves. If the judge, to realize, one of the young people that I'm hiring that are starting with me in a little over a month. He came in and started telling me stuff, and it's like, how did you know that? And he said, oh, I was driving down, my girlfriend was reading me from your judicial application. It's like, I like this guy.
That's sharp right there.
Yeah.
Well, again, thank you so much for your time. Thank you to all of you for watching, and stay with us for the next one. My name's Jeff Adelman with Fort Lauderdale, ABOTA. This is Judge Alan Forst.